Hi there. Welcome to this great and important for all of us webinar today. My name is Dean Serwin. I'm the chair of the wellness section here at the Beverly Hills Bar, and I was formerly the chair of the law practice management section who's presenting this important program. I'm going to give you a little background and then we'll jump in with Marshall Cole. So it's that time of year and it's that time of the 3 year for myself. I get to do my compliance, my MCLE compliance. The Beverly Hills Bar is fantastic for helping out with that. We have these programs. This is the second one I've introduced today. I'm sure there's going to be another one at 4 o'clock today. We have 1 to 3 of these a day. They're all available in the BHBA on demand locker room, sort of a YouTube for MCLE that we do. If you're like me and in the past you needed a few extra hours, you'd click on one of those emails, or back in the day, faxes that would come in offering you all 25 hours for $75. And the programs you'd get on, back then, VHS and then DVDs were awful. They were old, they were poorly produced, they were boring topics done by very professorial speakers that were hard to follow. BHBA, we've got programs like today's, important things that are important to your practice. If there's a new case that comes down, or important legislation, or just something important that happens in the business or legal world, we're probably going to have a program on it within a week. That program's then going to be in the on-demand locker room. I know it's not called that, but I like calling it that, where you can go and watch it again. After today, you want to review this, you can go and review it. You can send it to your partners, your associates, your friends, and say, hey, go check this out. So it's really fantastic. And then when it comes time, like it is for me, I guess we get an extension of a month now, to actually do that. All the videos that you watch, they're all participatory credit. They're there in a format and on a sheet. So all you have to do is a couple of clicks and you turn that into the bar and you're done, you're ready. And if you look and you need, like I do, I need some of those specialty hours, then you go into the on-demand and you go, hey, I want to watch this one on substance abuse. I want to watch this one on stress. And it's really easy to do. Appreciate the BHBA for having that available for us, and Lawyers Mutual that sponsors that. So let's get to this. There is a chat. There'll be some posts in there with the materials from today. It'll be monitored by the representative from BHBA who will repost those as necessary. This is a webinar. You can raise your hand. You can post questions in the Q&A. Marshall is going to work to monitor that, but there'll be a Q&A section at the end, so go ahead and post those there. And I'm going to introduce him, Marshall Cole, Protecting Your Fee Agreement So It Protects You. Great title. Marshall is the managing attorney at Nemecek Cole, a nationally recognized trial lawyer known for his success in complex, high-profile professional liability and civil litigation matters. Named by the Daily Journal as one of California's top professional liability attorneys, he is renowned for his proactive, solutions-driven approach and consistent record of winning results at trial. Marshall, thank you so much for being here today. I'm going to go off camera. Take it away.
Thanks, Dean, and thanks to the Beverly Hills Bar Association, as always, for having me. I prepared a PowerPoint here, so we'll work our way through it. But for starters, everything that we're going to go through today regarding fee agreements, I've pulled it's something my office has dealt with, and it most likely has dealt with within the last 12 to 24 months. So all these tips that I'm going to provide you with, or pitfalls that we're seeing, are real claims, either legal malpractice claims or mandatory fee arbitration issues that we're seeing, arbitration issues that we're seeing. And so as we walk through each of the slides, hopefully you're gonna leave with the ability to go back to your retainer agreement, take a look at it, and see how you can make it better, because there's oftentimes a poorly drafted retainer agreement can create a lot of issues in a legal malpractice case that are otherwise avoidable. And so if you draft it and it's tight and you've complied with all the rules, you're going to get all the protections that you put into that agreement that are going to benefit you versus having it potentially voidable by the court and set aside. So with that, I'll share my screen here and we'll work our way through the slides. If you have questions, feel free. I'll try to monitor it. It can get a little tricky with sharing screen, but I'll do my best here. So give me a second. All right. So really, these are the rules that I'm not going to go through each one of these rules with respect to this presentation, but you need to be aware of these when drafting your firm's fee agreement. And we'll touch on some of them, but again, I don't put the actual content of the rule. But this is just like 30,000 foot. These are the rules you need to focus on, and then we'll look at the Business and Professions Code as well regarding each of the aspects of your attorney-client relationship, from formation to referral fees to the responsibilities that the lawyer has, the responsibilities that the clients have, and then also withdrawing and concluding your services. If you find yourself in one of these situations, the first thing you need to do is refer to the rule. See what you need to do and what you can and cannot do. And then, of course, the second thing you can always do is call me or my office, and we can walk you through any issues that come up. We offer outside general counsel services to a number of firms, from sole practitioner to hundreds and hundreds of lawyer firms. So we're always just one call away. So after you've reviewed these rules, when you're starting to take a look at drafting your retainer agreement, the first thing you really need to focus on is, obviously, if you're going to have a contingency fee agreement or a non-contingency fee agreement, an hourly fee agreement. Both are governed by different code sections under the Business and Professions Code, and both have different aspects that you need to cover in order to make sure that it's in compliance with the rules. Both generally need to be in writing unless it's for very small amounts. Both need to be signed by the attorney and the client. And I know that sounds like such an obvious thing, but the amount of claims that I've handled where the attorney fee agreement is not signed by either the lawyer or the client is staggering. So many attorney fee agreements either don't come back signed or the attorney themselves never signed them. And again, just an easy mistake to avoid. And so some of this may seem like, of course, this is so obvious, Marshall, but I wouldn't be talking about it if it didn't happen on a regular basis. And sometimes it happens with people who never have this issue. And then, of course, they get busy and they forget to get it signed or sign themselves. So these are the two Business and Professions Code sections that are very important to know and understand when you're drafting an attorney-client fee agreement. And if it's been a year or 2 years or more since you've looked at your attorney-client fee agreement, you need to take the time after this presentation to go back and look at it and see if it's still applicable to the type of work you're doing, to the type of clients you're servicing, because I don't believe that retainer agreements are a form type of contract that you can take from one client to the next. You can certainly have a template, but you definitely want to take a look at it for each client to make sure that that particular agreement fits for what you're going to be doing. My office has a number of different types of attorney-client fee agreements for different types of matters that we handle: private business litigation, state bar matters, insurance defense matters, plaintiff side contingency matters, should we handle one of those. There's a number of different provisions that we like depending on what type of matter we have. And so if you're the managing partner of a firm, small or large, you really need to understand what retainer agreements exist within your firm and what's being sent out to clients, and make sure there's a large amount of oversight over that, because we've seen cases arise from retainer agreements that get sent out to a client which haven't even been approved by the firm's general counsel or managing partner, and they've modified and tweaked things, and lo and behold, firm gets sued, and now they're dealing with a retainer agreement that the managing partner didn't otherwise approve. So again, this requires a lot of oversight and a lot of ongoing diligence, similar to, I often give ethics presentations on conflicts of interest. And like a conflict of interest and a conflict waiver, conflicts modify and change over time, and you need to get your waivers updated. Now, an attorney-client fee agreement, it certainly can change, but you're not going to get more than one throughout the representation. But definitely, from one client to the next, you need to take a look at the agreement, make sure it complies with the rules, and make sure it's benefiting you and the firm in the way you want it to. And as we move forward here, if you don't comply, it can become a problem, and it can become a problem really fast. And each of these four issues that I've provided here as examples, we've seen very recently. The first one, I just resolved a case about 10 days ago, not because of the issue that both the attorney and the client didn't sign, but because the issue of the duplicate copy was not sent back to the client. So the way the rule works here, and it's a little bit overkill, but it's the rule. And what it says is, once the agreement is fully executed by the attorney and the client, you as the lawyer need to send a fully executed copy of that retainer agreement to the client. And the issues come up when the lawyer signs the retainer agreement, then they send it to the client. The client signs the retainer agreement and emails the agreement back. The lawyer often thinks, well, look, I've got a fully signed agreement. They clearly have the copy because they scanned and sent it, so I don't need to do anything. Or there's just an oversight altogether and they don't send it. The argument that was made in the case that I was defending was that it didn't comply with the Business and Professions Code because a fully executed copy wasn't sent, and a retainer agreement was voidable at the client's option. And the firm I was representing had a cross complaint for attorney's fees, and they were, of course, claiming that we shouldn't get those fees, or at best, we would be entitled to quantum merit, as you see there on the screen. And if that kicks in, depending on what your hourly rate that you're charging at your firm is, you may not be getting $1,000 an hour, $800 an hour. You may be getting, depending on your jurisdiction, $300 an hour. And you want to avoid that situation. Now, if the matter had, excuse me, proceeded to trial, I think in front of a jury, irrespective of the rule violation, I think we have a lot of strong arguments and evidence in those types of cases where I've dealt with this to sort of neutralize that, what I would characterize as like a ticky-tack sort of breach regarding the Business and Professions Code, but nonetheless it exists. And where it can really cause problems if you don't send it back and then the client raises it in litigation that it's voidable is with respect to an arbitration provision. If you didn't strictly comply with the rules and there's a petition to compel binding arbitration, I've had numerous courts deny petitions to compel binding arbitration, which were then affirmed on appeal because strict compliance was not adhered to. And so it's just a simple issue. And again, think of it, you've spent all this money, you've got this perfect retainer agreement, it's doing everything you want, it's protecting you, the client's protected, only for it to be voided because you just didn't send that duplicate copy back. And so I harp on this one a lot because it's such an easy one. And if you have a high volume practice, it's a very easy oversight. And so it's one that you want to have sort of standard operating procedure in place to ensure that your staff members or you are complying with this rule to just send it back, get that duplicate copy there, and then you've taken care of this issue. So the next issue that we see a lot is, and it's coming up more and more, is dealing with unconscionable fees. And because rates are getting so high in the city of Los Angeles and presumably in metropolitan areas throughout the state of California, courts are taking a harder look at what is an unconscionable fee. And so there's a number of factors in play that are listed here. Experience is a big one. And also now I want to point out on the contingency side, and other states have taken a much more hard line with this, which is quick settlements, right? If you're a contingency fee lawyer, part of the one perk of being a contingency fee lawyer is a quick settlement, right? You've got a nice 30% contingency fee, 40%, whatever it might be, and you get a big case and you settle it 10 days into the case or whatever it might be. The California case law is pretty clear that those fees are earned. That's a benefit of being a contingency fee lawyer, because of course, for every one of those cases you get, there's 20 where you work for 5 years and don't get a dollar. And so, despite that, I think courts are starting to take a different look at quick settlements, but also setting aside the rule and whether it's proper or not, dealing with these types of issues at trial in front of 12 jurors are creating certain issues that I am seeing. And look, there's nothing that can necessarily be done about it. If you're a contingency fee lawyer, you get a quick settlement and then you end up in litigation. You just have to neutralize sort of the greed component, but that's something that exists here. And again, if your firm's charging a high hourly rate, you really need to make sure that you're overseeing your associates, that the work is not being block billed, that the hours being charged are reasonable for the task, because bills are a very important part of the process and tie directly into the retainer agreement, especially if hourly rates are denoted in that retainer agreement. You're going to want to make sure that there's oversight there. And if you find yourself in a case where you've got a big receivable and you want to go collect it, the first thing that a savvy plaintiff's lawyer is going to do, if you're just dealing with a fee dispute, is hire a billing expert who's going to go through and chop up the bills based on block billing, hourly rate, skill required, lack of experience, all these factors. And again, you're going to have that huge receivable chopped up 50% at least. And if there was proper oversight from the outset, you would have potentially avoided that issue. So as we get into the actual terms of your retainer agreement, another part that's really, really important is the scope of representation. We see a lot of cases come up because the scope of representation isn't clearly outlined in the retainer agreement. And what I mean by scope of representation isn't just what you're going to do for that client. What's also really, really important is to identify what you are not going to do. And that's really where the issues come up. For instance, in my firm's retainer agreement, I don't care which version it is, every one of them is going to say that we don't give tax advice. We're not tax lawyers. I don't know anything about tax law. So when settlement money comes in or we're dealing with settlement, oftentimes questions come up. Is this taxable? How am I going to get treated with this with respect to this money? We refer them out to a lawyer who can specialize in that. No guarantees on outcomes is very important. Not to say that if you don't have something like that, the client can say he guaranteed me this outcome, but if you put it in the retainer, it's quite clear that you're not guaranteeing an outcome. And I think it's really important, especially for lay clients, to set their expectations from the outset. Look, we're going to do work for you. We're going to do our best, but we're certainly not guaranteeing a particular outcome. And then the other area where I often see, or two other areas where I often see issues is if you get a judgment, whether or not the scope of your retention is going to cover collecting that judgment. And then the other one is if there's a judgment, whether your firm is going to handle the appeal. And if you're silent on those two issues and you go through trial on a particular matter, there can become problems regarding whether or not the scope of your representation covered judgment collection or appellate work. And so I think depending on the type of work you do, it's really important to say what you're going to do and then again, what you're not going to do. Another big issue that we see a lot is a single retainer agreement for repeat clients. Repeat clients are great, some of the best people to deal with, but you've got to remember, no matter how many times you've been to dinner with that person, played tennis or golf or whatever it might be with that client, they really aren't your friend. And you really don't want to let your guard down. And when you start to have repeat clients, we let our guard down. It becomes more casual. One matter turns into two matters turns into five. And the next thing you know, you're handling a divorce and you do business litigation. Okay. You just want to have a single retainer for each matter. And it's not burdensome for the client. Everyone understands that contracts are a part of what we do, and it's the foundation for the relationship. And it just makes it so everyone's objectives are clear for that particular matter. And if you have a retainer agreement that's 6 years old or 2 years old from 7 matters ago, it's very easy when something goes wrong for that client to say, this agreement didn't apply to that. Look at what we're handling compared to what that retainer agreement applied for. If you are going to have a single retainer agreement, which says this agreement applies for this matter and any other future matters that we are going to handle, it better be, it certainly shouldn't be for litigation. It should be for ongoing advice, right? If you're servicing a client on an ongoing basis that spans a number of years, that's a different thing. And because you're handling the same thing within that scope of representation. Some clients that I provide outside general counsel service for, we have a retainer agreement and it enables them to pick up the phone, call me regarding general counsel advice. If it starts to get into a litigation matter, we have a new retainer agreement. I'm separately retained to handle the litigation matter, and we go forward just like that. Never once have I had an issue with it. And oftentimes I find the single retainer agreements come up in the entertainment context for whatever reason. So if you're an entertainment lawyer and this is something that's part of your practice, I would really try to eliminate it as best you can and just have a separate retainer agreement for each file. Let me just check and see if I have any questions here, if I can figure that out real quick. Q&A, hold on one sec. I got a few here, so give me a second. Okay, AI in your agreement, I'll touch upon. I think that would be better served. I've given a ton of AI presentations, but I'll touch upon whether you need to disclose that. Is the signature? The signature requirement is required. That's another question. So DocuSign is okay, but I don't do it. And I think I sort of have a negative view of DocuSign. I think even though a contract is when you receive it and sign it, you're deemed to have read it, right? That's well-established California case law. I think everyone in society DocuSigns things all day long, right? You go to the doctor's office, you sign that little gray box, and you don't even know what you're reading. So I think if you're at trial, you're going to run into more of an optical issue with a bunch of jurors and a client who DocuSigns something. Everyone's going to understand that they didn't read it. And what sympathies may come into play from there, who knows? So I think for a retainer agreement, just get the wet signature. I know that's asking a lot, and that's certainly best practice. That is not, I don't think your retainer agreement is going to be voided because it's a DocuSign. I'm here to tell you what best practice is. Have I had clients send back a DocuSign? I'm sure we have, but it is not something that I allow, certainly from the attorney end, and we always try to get a wet signature on a retainer agreement. Other types of documents, of course, I think e-signatures are okay with regarding pleadings and things like that. There's a question about Zoho Sign. I don't know what that is. I don't know what that is, so forgive me. There's a bunch here, so okay. If you hand the fully executed copy of the retainer agreement to the client right away, for instance, if they come and sign it in person, memorialize that. I had a case where a lawyer said, look, we signed it in person, and they walked out with the duplicate copy. Of course, the client disputed that. The court sided with the client, and so that wasn't enough. If you're going to let them walk out with the duplicate copy, memorialize it in an email. Great meeting you. Thanks for sending the retainer agreement. Maybe even attach it and say, here's another copy of it, or confirming that you walked out with the fully executed copy. That's what you need to do. If you don't memorialize it, I think you're just going to run into a credibility issue, and I've dealt with that. Someone asked, what is the greed component? The greed component is basically a plaintiff's attorney convincing a jury that a contingency-free lawyer getting a quick settlement and trying to keep the money is greedy. That's the greed component. If you get a $2 million fee after 10 days of work, a plaintiff's lawyer is going to have some impact with a jury that the lawyer trying to keep that fee is being greedy. They didn't really do the work. They didn't deserve the money. I disagree with that completely, and we've dealt with it in jury trials, but it comes up. and depending on the amount of the fee. That's just an issue to be aware of. It was sort of a comment I made. Let me pause on the rest of these questions um, because I've got to get through this, and I'm always happy to answer some via email. And then I will point out differences in my advice regarding purely transactional practices. For the most part, for those of you who are just handling transactional work, the fee agreement rules are the same. We handle transactional clients all the time. Most of the matters that we deal with regarding fee disputes of recent are transactional in nature: entertainment, tax, um, and trust and estates. So everything that I'm saying here applies with full weight to litigation, uh, as it does to transactional. So please don't think I'm ignoring one group over the other. I really group retainer agreements in two boxes: contingency and hourly. And so if you're a transactional lawyer, you're going to fall into the hourly portion of that. So let me jump back in, and I'll try to keep monitoring the questions as I go here. Okay, so this is another big issue. I keep saying that all of these are big issues, but client's authority over settlement. So it's really important to understand. You can point these types of things out in your retainer agreement. That would be a best practice. Certainly doesn't have to be a must, but understanding when it comes time to settlement, it's a good time to pull back out your retainer agreement and make sure everything is covered in there. If you're on the contingency, costs, where are those coming from? You want to make sure that you're complying and that your client's complying and that your client understands what's going to happen. But it's important to note in the retainer agreement what decisions the client, generally speaking, is going to make, right? Our clients really drive the outcome of critical decisions within a case. We as lawyers certainly have authority to make decisions on a day-to-day basis regarding a case without our client's consent, but they have a right to make informed decisions on critical issues. I gave a couple examples here. And depending on the type of practice you have, whether that's transactional or otherwise, and depending on your client base, you may want to have more of these types of items identified as examples in your retainer agreement than not. I don't necessarily have very many of these based on the type of business that I operate. And so, again, it's a really important point in time where we see things go wrong, of course, is when settlement comes up. And so these are prohibited provisions, which we have seen in retainer agreements, which have voided retainer agreements as a whole. Okay. The attorney certainly can't say, I have exclusive authority to do these types of things. A big one that comes up is that an attorney can settle the case if it's a good offer, if it makes sense, if it's in the client's best interest. If there's any attorney approval in there, you cannot have it. It's just something you can't do. And again, it's kind of shocking the amount of times I give these seminars, say these types of things, and then, 6 months later, we see a retainer agreement come in where this type of provision is against public policy and it's going to be voided. And it doesn't necessarily have to be tied to settlement. And we'll get to some slides regarding withdrawal, I think the next slide. You really don't want to have anything in your retainer agreement where there's sort of an if then, right? You don't want to be conditioning anything you can do on something else regarding the particular matter or the deal that you're handling, because it's going to most likely look like a voidable provision. And once there's a voidable provision in your retainer agreement, unlike contracts in general, where you can void out a particular provision or a settlement agreement where you see, an integration clause and a severance clause where the rest of the contract's going to survive. That's not going to happen in a retainer agreement. Either the retainer agreement is going to live or it is going to die. And I think for good reason, courts are going to view it in the light most favorable to the client, because we know the law, we know the rules, we drafted the contract. And so if we're going to try to shortcut something or frame it in our advantage in a way that's truly unfair to the client, courts can and should set those aside, and they do it quite often. So again, these are easy ones to try and avoid. Same thing with restricting termination rights. This also comes up quite a lot. You want to avoid these types of things. And if you are going to put in what happens upon termination, or what could happen upon termination, or what could cause a lawyer to want to withdraw, certain things are okay. In our retainer agreement and in most retainer agreements I see, and I certainly recommend, attorney-client communication is key. Number one. Number two, you as the lawyer are not required to do whatever your client tells you to do. If your client is not listening to you and not following your advice, you are certainly free to end the representation and withdraw. If that's in a transactional matter, it's certainly easier to do so than if you're in litigation. If you're in litigation, you've either got to get a signed substitution or you got to file a motion with the court. These are pretty clear rules, but it's important, again, to just accurately frame when it can happen, and so that the client is better informed. And claims arise often because attorneys try to withdraw, whether that's in any setting on the eve of a deal closing or litigation or trial date, too close in time to the event. And then the client is abandoned, right? They're sitting there saying, I can't do the work. That's a problem. If sometimes these types of issues come up at the very end of the matter, and these issues can get a little sticky, but you as the lawyer want to have the retainer agreement teed up and drafted in a way that it's been clear from the outset as to when you as the lawyer can withdraw and get out of the representation. If you don't have anything like that, it's not that you can't withdraw. Of course you can, but it's just better to have it clearly identified and the client has signed a document noting that I've read when the lawyer can withdraw from the representation. Because you oftentimes, if you're representing a new client, you don't know that person. You think things are going to go fine. You hope everything's going to go great, but then they stop listening to you and taking your advice, or demanding that you do things that are against either the strategy that you believe is in the best interest of the client, or any other myriad of reasons, and you want to get out. So that's really important, to have this just clearly outlined so the client knows what their rights are if this circumstance were to come up. This is a thing that I didn't used to see at all, and now am seeing quite a bit. And I think it's because lawyers are trying to characterize advance fees as retainers and aren't necessarily doing it right. And this is one that comes up more in transactional settings than otherwise. First and foremost, if you get an advanced fee, it can never be non-refundable, okay? And if you haven't earned that fee when the representation ends, you are likely going to have to refund the balance of the unearned portion of the fees. If you don't keep track of your time, that can become a more difficult issue, and you're going to want to avoid that at all costs. So the only time that you can have a true retainer, and these are rarer and rarer, is if the client is paying for your availability at will, right? Like they can call you, that you're available, you're jumping on a plane, you're doing something, and I'm retaining that access. I don't see that very often, and so that's can be a real problem. And again, I don't know why these are coming up, but again, because of that, I added this slide to note to all of you that if you get advance fees from a client, keep it in your trust account. As you earn that fee, withdraw it from the trust account. But the safest place for that money, for your benefit and the client's benefit, is for it to sit in the trust account until you've earned that. And when you do, you should have your invoices reflect the hours or whatever work was done to point out the fee's been earned, and you can take it out. Let me just try to hit a couple more questions here. Arbitration provisions I'll get to, don't worry about that. I would not, pre-authorizing settlement should not be a thing if I'm following that question. A client can't authorize a settlement when they don't know the number, even if it's a hypothetical. I don't think that's informed consent. I would stay away from that. Jennifer's question regarding settling out from under the agreement. If so, you're correct. Yes. If the settlement, sorry, I don't know if everyone can even see these questions, but the question is, the client may not settle without the attorney. Isn't it intended to indicate that the client shall not communicate on the side with the other side and settle out from under the agreement without the attorney, or excuse me, with the attorney? Yes and no. Number one, I don't think you can prevent your client from communicating with the other side if they want to communicate from the other side. I've never seen that provision, and also you can't prevent that. Clients can discharge you and then settle out from under you, and then you have a number of rights and likely would be able to get your full contingency fee based on the question. I'm assuming that's a contingency fee issue. And it would either be on quantum merit or another basis. And if it's quantum merit and you've done all the work to get the settlement, I've resolved cases where the full fee is obtained for the law firm based on the work that was done. And that happens quite often with clients who try to get out from paying their lawyer, fire the client, fire the lawyer on the courthouse steps, and settle around and try to keep the fee. It's never worked in matters that we've handled, but it does end up costing the lawyer a little bit of money. Okay. Can the attorney require the client to consult with an attorney before accepting a settlement? You certainly can do that. That would be an absolute best practice. It's not necessary at all. As long as you've conveyed the good and the bad of the settlement, I don't believe you as a lawyer need to recommend a settlement or recommend a settlement be rejected. Your job as a lawyer is to outline the scenarios of accepting or rejecting a possible settlement. And if they ask you, you can make recommendations, but I don't think you need to step into that world of making recommendations. I've had cases revolving around recommending and not recommending settlements. And I think, again, it's not something you need to do. And it's certainly not something you need to have in your retainer agreement. Okay, let me jump back in here. Keeping a credit card on file advisable. That's more of a collection issue. If you're accepting fees via credit card, you can certainly keep it on file. But if they don't, they really should be authorizing that payment each month. I don't think you can issue an invoice and then just charge the credit card, because your clients generally have the right to dispute your fees and if each month. And so if you're just charging, that could be a little bit of an issue. If I hope I answered that question. So let me pop back in here to where we left off. And again, I'll do my best to track additional questions. Okay. Give me. All right. The other thing that we see here is withholding client files. You really cannot do it. When the representation ends, the client's file is their property, other than your work product. You can keep your work product behind, but once litigation ensues, if you were to be a defendant in a legal malpractice case, your work product's generally going to get turned over as well. But for purposes of the client file, if there's a demand that's made for it, they're entitled to the original file at the end of the representation. This day and age, original file has become a little bit of a difficult thing to understand because paper files don't necessarily exist anymore. So it's really just your digital file on whatever software you're using, iManage or whatever it might be. If you're going to produce your original file to your client, based on their demand, make sure you make a copy of it. So for yourself, a lot of lawyers turn it over and then they don't keep a copy for themselves. And then the original file obviously can become tampered with down the line and create issues for a subsequent representation. So this is kind of just a very straightforward one. You also, if they haven't paid you, you can't say, I'm not going to turn over your file. As soon as the demand's made, you have a reasonable time to provide the file. Depending on the size of the file, a reasonable time obviously can differ. You certainly don't have to do it the next day or even the day after. You have a reasonable amount of time to prepare it and provide it to the client. So in relation to referral fees, which I'm a big fan of referral fees. I think it's a great part of in California. Uh, we can have and we can get and pay pure referral fees. You don't actually have to do work on the case in order to get the referral fee. Um, but you've really got to comply with some basic rules. Otherwise, your referral fee agreement, it can be voided. And this isn't necessarily just a client attorney issue. This can be a lawyer to lawyer issue. And quite often the disputes that we deal with aren't lawyer client. They are lawyer lawyer, right? It's a lawyer refusing to pay a referral fee and oftentimes using as a sword Rule 1.5.1 because it wasn't complied with. And courts generally have zero sympathy for lawyers who failed to comply with Rule 1.5.1 in relation to getting a referral fee, by and large, because it has nothing to do with the client's recovery. And so if you didn't comply with the rules, you're jeopardizing your referral fee. So number one, and I am going to kind of walk through this because it's very, very important. The client's informed written consent is extremely important. And if you don't get it, your referral fee is not going to be able to be paid. And it has to be done at the time the referral agreement is executed. There's case law on point where the client executed the referral fee agreement months or years later. They didn't object to it, they just did it too late. And the court held that the referral fee agreement that the lawyer was trying to enforce was not enforceable because the informed written consent wasn't at or near the time the referral was agreed to. You've got to identify the division that's made. You've got to obviously identify the lawyers. You've got to disclose that the client's fee, the client's portion of the settlement is not going to be negatively impacted. They're not receiving less money because of this referral, and that both lawyers execute the document. Another issue that I see with referral fees, and this happens to come into play more often on the plaintiff's PI catastrophic injury side, is the referral fee agreement is contained in the retainer agreement. The reason why that is problematic is because the retainer agreement can be voided for a number of reasons. And if you void the retainer agreement, you're very likely also voiding the 1.5.1 agreement. So best practice in this area is to have a standalone one-page document that is its own contract, that's not tied to any retainer agreement or whether you're doing work for that client anymore or whether you've been discharged. And it's a nice, clean document that exists. And when that settlement comes in, you pull it out and you demand the referral fee, and you shouldn't have any issues with that. So this is a really important rule to comply with and a separate document to answer, a separate document to execute if you're in the world of paying or receiving referral fees. See how we're doing here. Does production of a file include email communications you had with opposing counsel? I would say yes, it does. It doesn't include internal emails or memos. Again, that's going to be work product, but the client file is going to be defined to include that. You can put a shorter retention period, but you definitely don't want it to be with like a year or something like that. You have an obligation to maintain the client file for a period of time. Sorry, one other question here. Um, are there standards for referrals of hourly rate cases? It's going to be Rule 1.5.1. So if you referred an hourly case and you're getting, I don't know, 15% of the total at the end of the case, or whenever you break that down, you're just going to have to comply with Rule 1.5.1. Referral fees certainly can be dealt with in hourly cases just like they can in contingency. They're just more common in contingency fee cases. I have not dealt with a case regarding an hourly referral fee gone wrong. All right. Oops, excuse me. Okay. So this is an issue that comes up from time to time, which is the insurance disclosure. This is a newer rule. If you don't have insurance, California is one of the fewer states that you can provide professional legal services in without carrying professional liability insurance. I hope all of you listening to this have insurance, even if it's $100,000 through Lawyers Mutual, who sponsors these programs. Great company. I highly recommend you use them. And I highly recommend you have insurance, because if you don't have insurance, being sued becomes very expensive very quickly. And if you have insurance, this is a little bit stepping aside from retainer agreements. If you have insurance, make sure, number one, you report all potential claims at the time of your application. I have had a number of people come to me who've been denied because they failed to disclose a potential claim. A potential claim is, I lost at trial, the client was mad. Okay, that is how loosely an insurance company is going to view that and looking to deny coverage because you failed to disclose a potential claim on your application. The other thing that's important is, if you have insurance, is to timely tender the claim. We've had a number of cases where lawyers come to us because they got denied because they didn't timely tender the claim. They thought they'd handle it themselves. They thought it would go away. Next thing you know, it's a year, and next thing you know, they get denied. So if you pay money for this product, use it. If you don't have it, you need to have this disclosure in play. So, and if you lapse or it lapses, you need to notify your clients right away. So this is, I think, a rule that comes into play certainly for sole practitioners who are out there. And again, if this is something you're going to do, it is against everything that I advise to practice without insurance. But this is something you have to put in your retainer agreement, and I've seen it in various retainer agreements along the way. So the next thing I want to discuss, which is it's an older case now. This was the biggest case of the time regarding conflict of interest, advanced conflict waiver deemed to be unenforceable. And I've given a number of seminars on this case, and we could talk for at least an hour about it and the implications of it. But it's really important to know here, because it really touches on quantum merit and the guidelines as to how that's going to be treated. And it gets applied oftentimes when retainer agreements get voided, and you're stuck now getting in the world of quantum merit. So if you haven't read the Shepard-Mullen case, you should read it. There's just a very high-level bullet point summary of what it covers. But again, the main takeaway is, don't ever have an advanced conflict waiver, because they're generally going to be, unless it's very specific. And then as your conflict changes and evolves over time, you may need to update that conflict waiver when the actual conflict arises. So you have your conflict waiver at the start, and then you're going to modify it. So again, this is the case that's going to void a lot of agreements, and you should know and be familiar with it. That said, it does allow quantum merit recovery. And I've talked about quantum merit a lot. And the case law is pretty clear that even if the violations are severe, whether it be the rules of professional conduct, the Business and Professions Code, which is California case law, lawyers are entitled to get their quantum merit, but there are going to be things that are going to take away from it. And these factors that are listed here are the issues that are going to come up that you're going to be dealing with if you're in the world of quantum merit. And quantum merit comes up all the time once you're a defendant in a legal malpractice case. If you have a cross complaint for fees, it just comes up a lot. And so you really want to be careful if you did happen to take advantage of your client, or you were just had your pedal to the metal and were overbilling. These are the issues that are going to take away from quantum merit. And certainly the more serious the ethical violations, the more serious the conduct, the more willful the billing discrepancies are, the less likely it is that you're going to get the full value of the services. And again, as I noted at the outset, that sort of starts with the hourly rate. Let me just pop back to our questions here. Okay, text messages, are they part of the client file? I would argue they would be. I would also argue that, I would also tell you As the question points out, can an attorney inform the client not to communicate substantively by text? Absolutely. I don't think communicating by text is a smart thing to do other than for routine tasks, dates, scheduling, things like that. But if you're communicating settlement offers with your client, I don't think that's smart because, as we all know, when we text, we talk very casually via text. We abbreviate. There's nuance. If you throw in an emoji, it gets even worse. You just don't want to be communicating about anything serious via text message. If you have less sophisticated clients, that can become more difficult. So if you are going to communicate via text, and it's certainly you can do it, just remember that you're the lawyer, right? You're not their friend, and you need to do it formally. Send a text like you would send an email, so it's clear and there's no vague content in there regarding whatever important issue there is. Okay, let me jump back to the presentation here because I'm running a little light on time. And again, I'll answer any questions after the presentation. Okay. So this is an issue that's coming into play, which is fees that aren't necessarily contingency fees regarding these business and professions codes. So this is something to just kind of keep your eye on depending on if you handle non-litigation matters. Whether or not Business and Professions Code 6147 is going to apply. And we see words in retainer agreements, as you can see here, like hold back or bonus based on a deal, right? If you're getting pieces of the action, you're going to have conflict issues. But the question is going to come up of whether this is more like a contingency fee agreement versus something that was hourly. You certainly can weave these components into an hourly fee agreement. If you get a kicker on the back end regarding something, there just needs to be informed written consent, and you just need to make sure that you need to comply with the rules. So this is just an issue that's coming up that you should understand depending on your practice group. And forgive me, I'm kind of going a little fast here towards the end just to make sure we get into a couple other issues. Okay, so these, I believe we've kind of discussed this, but this is really the quick settlement slide. I'm going to move on from it. You just need to understand that other states are taking a harder position with respect to quick settlements, and the state bar has recognized that other states are doing this, so they may start to do it. And the state bar may take one view of something, and the California Superior Court may take another view of it. So if you're practicing in this field, just note that things may change. But I think until a California published decision comes out on the topic, there's not going to be any issue for you. So these are block bill entries and issues that we see with the bills themselves, and something that you're going to see if you look at the red slide there, which we see all the time. If you're putting commas in your bills on the transactional side or litigation side, it's bad practice. Is it malpractice? No, it's just something you should avoid, because the same task should be separated so that you can see the task, it's identified, there's more specificity, and a very qualified expert is going to have no problem slashing that 5.5 hours down to 1.5 hours, because you just can't tell what was done there and which one of those tasks took which amount of time. And so best practice here to allow you to keep your money when you've got that receivable and you're filing that cross complaint, or you're filing that complaint for fees, or you're in fee arbitration, is to have your bills look like this. Is it more time consuming? Absolutely. Are your associates going to give you grief about it? Absolutely. But this is the best practice, and this is how you get your money. So if you're the managing partner or you're running your own shop, you should, and you're billing with commas and semicolons and things like that, you should try to avoid doing that, because I think your bills will tell a cleaner story, and the bills will be upheld, and you'll be able to collect your money. Okay, so arbitration came up in some questions, and I definitely want to touch upon. So two issues: prevailing party fee clauses and arbitration clauses. There is no one size fits all here. It really depends on what you want to do. I have clients who do not include prevailing party fee provisions for a number of reasons. And it just comes down to whether you want one and whether you need one. My firm generally does have a prevailing party fee provision. Obviously, you know the downside of that. If you lose, you're going to be paying fees. If you win, you can get fees. The one thing that's important to consider, I think, above all, is who are your clients? And A. And B, are you ever going to collect a dollar from them if you prevail? If you have a prevailing party fee provision and you represent individuals with potentially little to no means, you are never going to collect that money. So why have it? Because if they win, you likely have potential money that's collectible. If you represent big businesses, that's a different story, right? They're collectible and it might make sense. But if you just have it because you've never thought about it, that's a bad approach. So you really want to think about whether you want one in your retainer agreement. And I think looking at it from the perspective of who your clients are is the best way to go about it. The next issue here, and I know we're running out of time, and this is the end, is arbitration. Okay, there used to be this common theme that arbitration was cheaper and it was quicker, and it used to be cheaper and it used to be quicker. That's not necessarily the case anymore. Depending on who your arbitrator is, it can be more expensive and it isn't necessarily going to be quicker. So again, before just including an arbitration clause in your retainer agreement, think about A, do I really want this to be private? Do I need it to be private? Am I the type of lawyer that I just cannot have any public filing against me? And period. If that's the case, so be it. The downside of arbitration is the following. We have a tremendously high success rate at getting clients out on summary judgment motions, anti-SLAPP motions, and defense verdicts at trial. If you don't get that in arbitration, okay? You just don't get an MSJ. It's not going to happen. Even a demur on a statute of limitations, we get out. Doing any of those things with an arbitrator is extremely difficult. Your case is going to be heard most likely on the merits, and you're going to get a decision. Certainly, we prevail in arbitration quite often as well, but we don't have as many weapons available to us. And then, of course, if things do go sideways in arbitration, your right to appeal that decision is much more limited than it is in the superior court. So you really got to weigh whether or not arbitration is important for your firm based on the various needs that it has. And so, again, there's no one size fits all, and it's a really complicated discussion versus the costs and benefits. Because if you don't need it to be private, then honestly, it may not be that important to you. I have some insurance companies that tell their insureds, if you have an arbitration provision, before you can invoke it, you have to get the permission of the insurance carrier, because insurance carriers are pretty aware that they get good results in the superior court or federal court, wherever it might be, because of motions for summary judgment that attack causations and other things like that. And also, if you don't have a high insurance limit, let's say you have $500,000, then you're going to run into an issue with respect to eroding limits, because again, a private arbitrator can unnecessarily cost money that and erode the limits when it otherwise would. So I know that was a little bit quick, but those are generally the issues that come up with two hot topics: prevailing party fee clauses and arbitration clauses. And I have clients go both ways on it, especially arbitration. And it is certainly for those same firms, it's a discussion that has evolved over time. So just lastly, we've touched on these pitfalls. This is kind of summarizing everything, and you're going to get these slides. So feel free to call or email me to discuss any of these issues. These are the key takeaways for all of you. And then lastly, if you have any issues, feel free to call or email me. And I think I cut it right on time.